qualification is not necessary for a teacher to join a minority institution. Therefore, your refusal to accept this teacher is not fair. That is, my lord, the common fact in all of these books. Now there, our contention is, my lord, that that paragraph in Pramati Educational has not been correctly read by the High Court. And, my lord, so in one sense, my lord,
just one
yes,
clarification.
yes,
There could be aided schools, there could be unaided schools.
that's right. Yes.
But each school has to obtain sort of recognition or approval because they have to be recognized by
some
state
board. Yes,
board.
correct.
So therefore,
That is not the issue, my lord.
that's not the issue.
Because we are talking about the appointment of teachers. Yes.
The proposition that you are trying to advance,
Yes.
that 23 or for that matter RT will be applicable confined only to the TET qualification.
Yes.
It is only for aided schools, not for unaided.
Because as far as the facts of these cases are concerned, they all arose when they came for the aid for that particular person.
But Mr. Gupta,
Yes.
if we have to decide this matter,
Yes.
we have to keep in mind the ambit of 25 and 30
Yes.
of the Constitution.
Absolutely.
Because that's where the minority institutions will rely upon.
That's right.
So whether it is aided or unaided may lose significance.
Philip, that depends upon your lordships, the way your lordship looks at the TMFI Foundation. So, my lord, let me summarize it very, very shortly. Pramati Educational, does it or does it not say that the entire RTE will not be applicable to minority institutions? That's the question. And as far as we are concerned, my lord, our submission is that there is a very long line of authorities of this Honorable Court now, which says that even in the case of minority institutions, regulation, of course reasonable, regulation of teacher qualification is permissible. Your lordships have held that in St. Xavier's onwards, all the way down to several judgments now also. So therefore, if this is a provision for regulating the educational the qualifications to become a teacher, and that is a permissible restriction even in the case of a minority educational institution, in that event, that line of authority, blood, can't be avoided by looking at one paragraph, blood, in from the educational institution. That's, blood, our submission. The paragraph 55 of Pramati should be read in such a manner that it is harmonious with the entire line of authority. And here, my lord, is perhaps what Mr. Shiva Balamurugan, I think he's here, might perhaps, my lord, be suggesting that what if there is a conflict between Pramati and the other matters? Even assuming that there is a conflict with a bench which is larger than Pramati, should it not be sent to a larger bench? Is that the point that you wish to raise?
In fact, we will be also raising one more issue, which is that TMFI, which is 11 judges, covers this specific issue as far as minority institutions is concerned, and says that specifically on selection of teachers and their qualifications, as long as you have some rational process, because I can understand your lordship's concern, can we just arbitrarily pick somebody who has absolutely zero qualifications, who may not even be a 10th pass as a teacher as a minority institution? At least for me, I'm saying no, you cannot. I'm going by TMFI, which in 11 judges says that you can use your own qualification as long as it's rational. So as long as it's rational, we don't have to ascribe to the TET requirement. So if they have PAT, they have other qualifications, which are rational ones, which will be something we can justify, that should suffice. So it's not only Pramati, it would also be Pramati, but it's also TMFI in 11th.
Tamil Nadu, there is also an act, Private Schools Regulation Act of 23, where they've made it requirement as a necessary requirement for all unaided schools, including minority and non-minority. The question was whether it is applicable to unaided.
Right.
So
It is applicable.
Tell us one thing.
Yes.
as per the act.
Yes. So the question that is coming to our mind is, let's see if the RTE Act is held to be not applicable to minority institutions.
Yes.
Per se.
Per se.
Let us assume the widest possible
Yes.
interpretation,
Yes.
which has been given by the High Court, is accepted. Then also you are not denuded of the power Because you'll be having your local acts. For instance, in Delhi, we have the local act, Delhi School Education Act, and the rules thereon. The state prescribes conditions which have to be fulfilled, or the minimum qualifications which a person must possess to be appointed as a teacher. You can incorporate that. No, if they have prescribed TET and this para 55 says the entire act does not apply to minority teachers.
Yes.
That does not dilute.
No,
the
it
power
does
of the
not
state.
dilute the power. No.
And education falls in this too. So the state may prescribe a qualification. You may prescribe a higher qualification than the local act.
There is a local act. But the local act is also TET.
Therefore, even if para 55 is upheld,
Yes.
in the widest possible terms,
Yes.
then also that TET will be required.
Milord,
You pitch it on that also then.
Milord, only thing is this, Milord, that this TET qualification has become so standard now across the country that Tamil Nadu, Milord, does not wish to step out of line and say that there can be a different examination.
No, fair enough, but if you have stipulated that requirement in your local act,
Yes.
please show that also.
So then that will be different cause of action.
No, no.
Entire thing will become infractions.
Then it will be covered under the next act.
That is a different cause of action once they are coming with the new act.
Clarifying the lead matter here for the institution, our contention is definitely there can be regulation, but there has to be regulation for the state act. Our contention is that it can't be through the RT Act, and now the state has in fact recognized that, and in 2023 they've made it mandatory. That is our stand.
No, but Milord, only one thing. Even R. Barun's judgment, Milord, deals with this in great detail. That if there is a central legislation on the point, you cannot, by way of state legislation, dilute the qualifications. Because, Milord, being in the concurrent list, if there is a central act, then, Milord, the state cannot legislate something contrary.
No, they
But
can't
of
win
course-
presidential aspect.
No, of course. But of course, Milord, if, for instance, if the RTE Act does not apply to minority institutions at all, then of course there is no question of conflict. Some legislation may be made, which, because the RTE is not applicable, therefore it can't be said that the central legislation is in conflict with the state legislation. But Milord, just to simplify things, Milord, I must tell your Lordship that we are not keen to move away from the proposition that it is TET and not something else. Milord, because the state has got settled. And Milord, the TET is working to whatever extent, Milord, it is working well. And we do not wish, Milord, now to have a different system, and then your Lordship will see the entire idea was by section 20 to have uniformity across the country also. One authority, NCT, was to be authorized by the central government to decide the minimum qualification. So therefore, Milord, that was a purpose there. And frankly, Milord, at this stage, we are not interested in making different rules and regulations, Milord, for Milord different states.
Any act derives from that, my lords. It has to from section 23 of the RT Act only, my lord. So they cannot make it anywhere 21A. That gives power to 23 RT 20 from 23 they can make any kind of act, but here once goes everything, then they cannot do anything.
No, that's
I might just point
That
out
is
that
not
the
good.
notification of our NCTE, which lays down what the qualifications are, the August 2010, which my friend was going to read, refers to a whole bunch of qualification, then puts and says TET.
yes, correct.
So it's not that TET is only requirement. You
No.
need all the others plus TET. The question here is limited to and TET. Does it have to be
So answering Lordship's question, Lord,
Milord, the TET is not.
capital A, there has been an amendment to the NCT Act specifically saying that they will determine the qualifications of all teachers in schools. And the word school in NCT Act, Lord, has been defined as all inclusive. Any school recognized, therefore there they do not make a distinction between minority and non-minority. Therefore, Lord, whether the regulation is only with respect to, respect to the RTE Act or the power of the NCT to prescribe such qualifications for all schools. Thank you, Lordship.
No, RTE Act governs all schools. It's not as if the RTE Act is only restricted to aided
Here 2N is there. Last time you showed us.
Yes, everything.
In fact, the recent Madrasa judgment of this court,
Yes.
where they allow an exception for madrasas based on the fact that they may not strictly be schools under RT.
But here there is judgment 55, 54, 55, 56 of Brahmadi straight away it says that RTA is not at all applicable to this case, Madam. Once that view, then three views are possible, Madam. Once Lordship is accepted, then it's end of the matter. Otherwise, if Lordship is not agreeing, matter can be referred to larger bench. Third view is that matter can be heard and distinguish that particular judgment and render judgment. That is only three views. So our view is that only after reading the only 4 paragraphs, the court's time will be saved. The act is not at all applicable, so therefore
This is only one part of the controversy.
Yes.
The motion part did not go to a fine judgment or a C judgment.
it's true.
Therefore, we have to hear.
My case, first case,
So we have to hear the commission.
For completeness, the teachers in fact undertook refresher courses and the government in fact gave them certification. When a turn comes, I point that out.
Let us test. Otherwise, we are just.
May I please, Miller? No, they are not standalone. We also have the NCT Act.
Right.
That's what I'm.
Very well. Please don't interrupt, Mr. Gupta. Let us complete the stage stand thereafter. Yes, Karen.
Yes. Milord, I was telling you, so may I now come to Milord the notification so that your Lordship has a very clear view as to what the effect of all this is. Now that notification, Milord, if I may show your Lordship from the application.
Sir, 156.
No, not, yes, page 156 of the IE. Yes.
Yes.
No, Milord, now the IE has to be found. Yes, this one. So page 156, Milord, if your Lordship has, is of the IA. If I may just, this will give your Lordship, Milord, a complete picture of the kind of Milord, qualifications which have been laid down by NCT. So 23rd August 2010. And Milord, I'll place this in some detail, Milord. In exercise of the powers conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act, etc., and in pursuance to notification of 31st March 2010, issued by the Department of School Education, etc., the National Council of Teacher Education hereby lays down the following minimum qualifications for a person to be eligible for appointment as a teacher to class 1 to 8 in a school referred to in clause N of section 2 of the Act 2009 with effect from the date of this notification. Then, my lord, minimum qualifications, first category is classes 1 to 5, senior secondary, etc. Those are the academic qualifications. And B, pass in a teacher eligibility test to be conducted by the appropriate government in accordance with guidelines framed by NCTA for that purpose. Now, this is mostly, my lord, to train you in the train you to be a teacher. Now, the first is academic qualifications. The second is teacher eligibility qualifications. So, TET. That these are both to be taken into consideration. Then class 6 to 8. Again, my lord, BA, BSc. First, in the first lot, you just needed to have secondary qualifications. In 6 to 8, you need a graduation. And there again, your lordship will find B and pass the teacher eligibility test to be conducted by the appropriate government. So this is the first of the notifications. The second notification is at page 158 in continuation of this very application.
158.
158.
That's a continuation of this notification.
Yes, that's a question.
It starts,
the next
Hindi
one.
version starts 159.
Yes,
English version at 161.
yes, that's correct. Yes. Now, my lord, this is on 29th of July 2011. This is an extension of the time, basically, saying that up to this date it is all right if you haven't got it. So, my lord, I'll just place the first paragraph. The exercise of the powers conferred, etc. The National Council for Teacher Education hereby makes the following amendments to the notification published in Gazette, laying down the minimum qualifications for a person to be eligible, etc. Then again, my lord, and pass the teacher eligibility test. Then see, my lord, the fourth paragraph here. For para 5 of the principal notification, the following shall be substituted. Teachers appointed after the date of this notification, where an appropriate government to so-and-so has issued an advertisement to initiate the process of appointment prior to the date of this notification. Such appointment shall be made in accordance with the NCT Regulations 2001 as amended from time to time. So see, my lord, 2001 was prior to the RTE Act. The RTE Act is of 2009. There was already NCT regulations in place before that didn't have the TET. So the effect of this is that TET is not to be taken into consideration for those who are appointed pursuant to advertisements initiated before. Then will not kindly come to the second notification of that. No, I've placed 161. I've placed 161. Just give me one.
Third is at 167.
Yes, right. Just one. Yes, the third one, my lord, is actually 12/1/2014. So, my lord, this date, before I move forward, this is the date which is identified by your lordship in the order. The second notification's date is the date which your lordship has identified in the order, namely 29th of July 2011. So, my lord, that becomes the operative date from which, my lord, TET will have to be possessed. Before that, not necessary. Now, my lord, the third notification, which is of 12/11, that, my lord, is more relevant for the purpose of promotion. I'll tell you, lordship, why. Because, my lord, for the first time we find that in the notification, the question of promotion is taken into consideration, but only for the purpose of saying that your qualifications, the academic qualifications, will be a little different for the promotional cases. That, my lord, is an aspect which I'll go into when I'm dealing with the second proposition. So, your lordship has seen here 29th of November to July 19, 2011.
29 July 2011.
Now, my lord, kindly come to straight away to the Pramati Educational Trust.
So this 12th November 14, when is that reference to promotion?
Yes, if your lordship wishes to see that. It starts, my lord, the English version at least starts at 167. Yes. And, my lord, in this so clause 4, if your lordship sees qualifications for recruitment, A is the qualification for recruitment of teachers in any recognized school imparting pre-primary, primary, etc., etc., shall be given as in the first and second schedule annexed to these regulations. Then B, for promotion of teachers, the relevant minimum qualification as specified in the first and second schedule are applicable for consideration from one level to the next level. Till this date, my lord, none of the previous notifications said anything about anything different for promotion of teachers. It doesn't mention the word promotion.
So prior to 2014,
yes,
those teachers who did not have TET were still promoted.
Yes. Till such time, my lord, as the judgment in R. Varun's case comes, and of course that series of matters, promotions were possible without TET. In fact, my lord, there was even a rule to that effect which the Tamil Nadu government had issued, which rule got struck down in the Varun. Now, in the Pramati Educational Trust, the way the Pramati Educational Trust comes to this order, this court, my lord, is that there was a judgment. Please see, my lord, at page. How do we get it? Oh. Now, my lord, it's going to be very difficult.
That Rajasthan judgment is filed.
We have filed. No, not the Rajasthan judgment.
Page number 243.
No, this compilation we have got it because of stickers. 8. Is there? 8. Sticker 8, Roman 8.
But my lord, then, yes, your lordship has got. No? Your lordship will have to go by the flagging, my lord. I hope.
Yes, yes.
Your lordship. These are tabs, my lord, in accordance with English terminology, my lord,
Yes.
tabs.
Yes.
So here, if your lordship looks at the second page, page 2 of the report,
Internal page.
internal page 2, right at the bottom, a 3-judge bench, when it's stating the facts, a 3-judge bench by its order dated 6th of September 2010. The second page of the report itself. The report is 2014-8 SCC, page 1.
Yes.
And at page 2,
Yes.
right at the bottom,
Yes. Private schools of Rajasthan.
the 3-bench decision of this by its order of 6/9/2010 in Society of Unaided Private Schools of Rajasthan made a reference to the Constitution bench to decide on the validity of Article 51(5) of the Constitution inserted by the Constitution 93rd Amendment Act 2005 with effect from 21/2006 and on the validity of Article 21 capital A of the Constitution inserted by Constitution 86th Amendment Act of 2002 with effect from 1/4/2010. The substantial questions of law before the present constitutional bench were whether by inserting clause 5 in Article 15 of the Constitution by the Amendment Act, Parliament has altered the basic structure or framework of the Constitution, whether by inserting 21A, the Parliament has altered the basic structure or framework of the Constitution. Now, my lord, this is the reference. Then, my lord, ultimately, my lord, the application is to the Right of Children to Free and Compulsory Education Act, which your lordship will find at page 6 onwards. And my lord, to shorten the effort, my lord, because I don't propose to take your lordship through this judgment, except, my lord, the relevant portion which my learned friends mentioned just now. Just see, my lord, the head note itself at page 7, top. The word state in Article 21 capital A can only mean the state which can make the law. Hence, the constitutional obligation under 21A of the Constitution is on the state to provide free and compulsory education to all children of the age of 6 to 14 years and not on private unaided educational institutions. Article 21A, however, states that the state shall by law determine the manner in which it will discharge its constitutional obligation under 21A. Thus, a new power was vested in the state to enable the state to discharge this constitutional obligation by making a law. However, Article 21A has to be harmoniously construed with 19(1)(g) and 31 of the Constitution. There is nothing in 21A which conflicts with either the right of private unaided schools under 19(1)(g) or the right of minority schools under 30. But the law made under 21A may affect those rights under 19(1)(g) and 31. The law so made by the state should not therefore be such as to abrogate the right of unaided private educational institutions under 19(1)(g) of the Constitution of the right to the minority schools, aided or unaided, under Article 331. Then, my lord, that it goes back all the way to my lord Venkatramana Deva. However, the Mulki Peet matter. However, admission of a small percentage of students belonging to weaker sections of society by granting them freeship or scholarships, if not granted by the government, and the admission to some of the seats to take care of poorer and backward sections of the society may be permissible and would not be inconsistent with the rights of 19(1)(g). The element of voluntariness can be subjected in law under power. So therefore, my lord, the first question considered was 19(1)(g), because that would apply to all schools, whether minority or not. Then your lordship will find, I'm going to the next page, my lord. The second paragraph at page 8, under section 12(1)(c), read with, that is of the NCT, of the Right to Education Act, read with section so and so 2N, an unaided school not receiving any kind of aid or grant to meet its expenses from the appropriate government or the local authority is required to admit in class 1 to the extent of at least 25% of the strength of that class children belonging to weaker section and disadvantaged groups in the neighborhood, and provide free and compulsory education, elementary education, till its completion. And under section 12(2) of the Act, such a school shall be reimbursed expenditure so incurred by it to the extent of per child expenditure incurred by the state, or actual amount charged from the child, whichever is less, in such manner as may be prescribed. Thus, ultimately, it is the state which is funding the expenses of free and compulsory education of the children belonging to weaker section and several groups of the neighborhood, which are admitted to be private unaided schools. These provisions of the 2009 Act are for the purpose of providing free and compulsory education to children between the age group of 6 to 14 years and are consistent with the right under 19(1)(g) of the Constitution as interpreted in TMA by Foundation, etc. However, that's the main thing. However, the power under 21A of the Constitution vesting cannot extend to making any law which will abrogate the right of the minorities to establish and administer schools of their choice. If the 2009 Act is made applicable to minority schools aided or unaided, the right of minorities under Article 31 of the Constitution will be abrogated. Therefore, the 2009 Act, insofar as it is made applicable to minority schools referred in clause 1 of Article 30, is ultra-vires the Constitution. Thus, the majority judgment of the Supreme Court in Society of Unaided Private Schools of Rajasthan, insofar as it holds that the 2009 is applicable to aided minority schools, is not correct. Now, my lord, your lordship will come straight away to paragraph 55. This head note is a little, of course, according to us, not in accordance with the paragraph, but now
there are many pages of written submissions, so it's at page 270.
Yes.
270. There's nearly 100 pages of written submissions which are immediately open.
Yes.
So now kindly come to paragraph 55.
Judgment starts at 243. Paragraph 55 is at 270.
270.
270.
270 of the report.
When we look, your lordship,
Yes.
so if I may trace from paragraph 54, because your lordship will have to take a complete look. Under Article 30 of the Constitution, all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Religious and linguistic minorities, therefore, have a special constitutional right to establish and administer educational schools of their choice. And this court has repeatedly held that the state has no power to interfere with the administration of minority institutions and can make only regulatory measures, and have no power to force admission of students from amongst non-minority communities, particularly in minority schools, so as to affect the the minority character of the institution. Moreover, in Keshavananda Bharati, Justice Sikri has gone to the extent of saying that Parliament cannot, in exercise of its amending power, abrogate the rights of minorities. To quote the observations of Justice Sikri in Keshavananda Bharati, I'm placing because it's a very important paragraph in the history of our constitutional jurisprudence, not directly relevant here. The above brief summary of the work of the advisory committee and the minority subcommittee shows that no one ever contemplated that fundamental rights appertaining to the minorities would be liable to be abrogated by an amendment of the constitution. The same is true about the proceedings in the Constituent Assembly. There is no hint anywhere that abrogation of minority rights was ever in the contemplation of the important members of the Constituent Assembly. It seems to me that in the context of the British plan, the setting up of the minority subcommittee, the advisory committee, and the proceedings of these committees, as well as the proceedings in the Constituent Assemblies mentioned above, it is impossible to read the expression amendment of the Constitution as empowering Parliament to abrogate the rights of minorities. That's a very important passage. Thus, the power under 21A of the Constitution vesting in the state cannot extend to making any law which will abrogate the right of the minorities to establish and administer schools of their choice. Then 55. When we look at 2009 Act, we find that section 12(1)(b) read with section 2(n)(2) provides that an aided school receiving aid and grant, whole or part, of its expenses from the appropriate government or the local authority has to provide free and compulsory education to such proportion of children admitted therein as its annual recurring aid or grant so received bears to its annual recurring expenses, subject to a minimum of 25%. It could be more than 25% also. Thus, a minority aided school is put under a legal obligation to provide free and compulsory elementary education to children who need not be members of children of the minority community which has established the school. We also find that under section 12(1)(c) read with 2(n), an unaided school has to admit up to 25% of the strength of class 1 children belonging to weaker section and disadvantaged groups. Hence, unaided minority schools will have a legal obligation to admit children belonging to weaker in the neighborhood who need not be children of the members of the minority community which has established the school. While discussing the validity of clause 5 of Article 15 of the Constitution, we have held that the members of communities other than the minority community which has established the school cannot be forced upon a minority institution because that may destroy the minority character of the school. In our view, if the 2009 Act is made applicable to minority schools, aided or unaided, the right of minorities under Article 30 would be abrogated. Therefore, 2009 Act, so far as it is made applicable to minority schools, is ultra vires the Constitution. We are thus of the view that the majority judgment in the Society of Unaided, etc., insofar as it holds the 2009 Act is applicable to aided minority institutions, not correct. Now, my lord, our contention is very simple. The entire discussion is relating to admission of
the school of students.
the students, and that is the protection which the court is consciously giving, that you cannot take away the minority character of an institution by having a law which requires them to accept 25% or more of its batch of students who are not of the minority. Having said all that, Lord, in my respectful submission, Lord, that last line, therefore the 2009 Act, insofar as it is made applicable to minority schools,
You said that it should be confined only.
it should be confined to 12, nothing else, Lord, because that's the one which is objectionable according to you.
You see my view?
Yes, yes,
Just trying to find out.
yes,
NCT Act was challenged,
yes.
and this court has NCT.
The one which is set up,
NCT.
this authority is itself set up by a statute.
By a statute.
Yes,
Yes.
NCT Act was challenged.
right.
NCT Act.
NCT Act,
Challenge was spurred
yes, that's right,
by this court.
that's right.
Now what happens? What does the NCT Act say? NCT Act was initially with the idea of regulating the training institutes,
That's correct.
PAPT training institutes. So it said that you need to have the recognition of the NCT before you award degrees. And if you award a degree without having recognition, it's only a paper degree. This came up for challenge before the Supreme Court. Supreme Court has upheld that. Just find out whether there is anything with regard to minorities also.
We'll check.
Because that would also abrogate minority rights. Why would a minority say that we would be submitting to the jurisdiction of NCT? Why should we have your recognition? That is one thing. The other thing is, in West Bengal, there was a Madrasa Service Commission.
Yes.
There was an act.
Yes.
The High Court had struck down that act, saying that this is abrogating the rights of the minority.
Yes.
It should have commission
Yes.
recommend.
Yes.
But the Supreme Court reversed the High Court.
Appeal the act,
Upheld the act.
that is
Therefore, that has to be considered.
yes, yes, of course. That pilot is the second judgment in the appendix of authorities.
Very good.
That is
That's a three judgment judgment.
That's correct. Contai Rahmania High Madrasa.
That's a three judgment. What reasoning was given
Yes.
by this court to uphold that act?
Correct.
That also abrogates the
But
minority
that is
rights.
directly on the point that the matter of regulating a teacher's training, the state can regulate that even for minorities.
We'll continue at 2.
Yes.